Hello everyone, my name is Kirk Angel and I want to welcome you to this, our first lecture or perhaps mini lecture in a series of lectures regarding employment law topics. Our topic for today is going to be the employment at will relationship. However, before we get into the specifics of the employment at will relationship, I do want to warn you that the information today is for educational purposes only and is not meant to serve as legal advice. If you're currently facing a legal issue in the workplace, you should immediately contact an attorney who practices employment law and who is licensed in your jurisdiction. I guess also by way of a short biography, I have to tell you a little bit about myself and give you some information about my experience in handling employment law. I began practicing law in 1997 in Tennessee. Since that time, I've focused my career almost entirely in the area of employment law. First as a private practice attorney in Tennessee, and then later as an attorney for the federal government. I worked for an agency called the U.S. Equal Employment Opportunity Commission, which is the federal agency in charge of enforcing workplace discrimination laws. You probably actually have heard them referred to as the EEOC. I served as a trial attorney for the EEOC for about 3 years, handling litigation in North and South Carolina. After that time, I opened my own practice in North Carolina, where I focus on employment law for employees, although I have in the past few years expanded my practice and begun representing employers, primarily small to medium-sized employers in employment law matters. I currently hold an AV or preeminent rating in employment law from Martindale-Hubbell. I also hold a superb rating in employment law from AVO. Since 2003, I've been on the faculty of a large university where I regularly teach human resource topics, including employment law. Before we go any further, let's talk about employment law as we know it today and how it developed. We imported our law in the United States and our whole system of courts from England. If you want to think back to high school history, you'll remember that the early days of the United States as a colony of the English Empire, we were primarily an agricultural or agrarian society. We really didn't have the types of industries that we have today. We didn't really have a concept of an employee in the same manner that we have today. In fact, our concept of an employee that we have today really didn't even develop until the 1900s, after the Industrial Revolution. Why is that? Well, it's because prior to that, being an agrarian or agricultural society, we really didn't have a need for lots of people working for us. But when we began to develop manufacturing jobs, industry jobs, then we had a need for employees who worked for us on an ongoing and regular basis. Much of employment law is focused or perhaps founded on agency law. Agency law is the law that deals with the agency relationship between a principal who contracts with someone, an agent, to do something for them. If there's no contract to the contrary, an agent can be terminated basically at any time by the principal. Now, we introduced that concept from agency into our employment law relationship, and it's developed today to what we refer to as employment at will. The basic concept of employment at will is easy to understand. In an employment at will relationship, either party to the relationship can terminate the relationship at any time for any reason. Now, there's probably some of you out there that remember the old country music song that had words to the effect of, you're going to go to the boss and tell the boss to take this job and shove it. You, as an employee at will, are free to do that at any time. You can go to your boss, your supervisor, and say, hey, look, boss, I'm done. I'm quitting. I am gone today. And there's absolutely no liability for you if you do that. In other words, the employer cannot sue you or harm you in any way legally because you've left. Now, some of you are going to say, well, Kirk, isn't it true that I have to give a 2-week notice? The answer to that legally is no. You, as an employee at will, are not required to give any form of notice, whether it's a 2-week notice or otherwise. Now, years ago, there became an HR policy that an employer wanted to make sure an employee who was resigning allowed them a transition time. So the HR policy developed that an employee would give a 2-week notice, and if that employee didn't give a 2-week notice, then the employer would perhaps do something such as mark the employee not eligible for rehire. However, there was nothing legally that the employer could do to punish the employee at will because they quit with no notice. Now, there is a flip side to an employee's right to resign or quit at any time, and that is the employer's right to terminate the employee at any time. As many state courts, including the court in North Carolina, has put it, an employee at will can be terminated at any time for any reason. They can be terminated for a good reason, for a bad reason, or for no reason at all. Let me give you an example. Let's say that I own a convenience store. And tomorrow I come in and I'm looking through my video cameras and I see that my employee, my cashier, is stealing money out of the cash register and putting it in his or her pocket. So I terminate the employee on the spot for theft. Now, I believe that all of us would probably agree that terminating an employee for theft is a good reason to fire that employee. If that's the case, and I've terminated the employee because of employee theft, that employee at will cannot file a legal, or at least a valid legal claim against me for that termination. However, the employment at will relationship, the employment at will doctrine is broader than that. I can also, as an employer, terminate an employee for a bad reason. Now, let's say that I go out drinking tonight, I have way too much to drink, I come in tomorrow morning and my head is hurting me really bad, and my cashier says to me, "Good morning, Kirk, how are you?" And that hurts my head because I've got a hangover. I fire the employee on the spot because the employee hurt my head by telling me good morning or hello when I have a hangover. Is that a bad reason to fire somebody? Absolutely. However, for an employee at will, if that is the only reason that I've fired them, they're not going to be able to file a legal claim against me. Additionally, if I come in tomorrow and I decide, you know what, I'm kind of bored. What do I want to do today to liven things up? I know what I'll do. I'll fire someone today. Eeny, meeny, miny, mo, you're fired. So I fired the employee for absolutely no reason at all. There is no legal claim the employee can bring against me if they're an employee at will, and I've really fired them for no reason at all in an employment at will jurisdiction. Now, some of you are going to say, well, Kirk, I know that there are times that Employees file wrongful termination lawsuits against their employers. If there's this employment at will doctrine out there and you can't sue your employer for terminating you for a good reason, for a bad reason, or for no reason at all, how do these folks file wrongful discharge claims? And the answer is, although an employer may terminate an employee at will at any time for a good reason, a bad reason, or no reason at all, an employer may not terminate an employee at will for an unlawful reason. And generally, when we're talking about unlawful reasons, we're talking about one of two unlawful motivations. One unlawful motivation would be unlawful discrimination. And the other general unlawful reason would be unlawful retaliation. Very important, however, that you focus not on the word discrimination or on the word retaliation, but on the word unlawful. There are very few forms of discrimination or retaliation that are unlawful. Now, in a later series in this lecture, we will talk about those unlawful forms of retaliation and unlawful forms of discrimination. But it's most important to remember that unless the employer's conduct is motivated by unlawful discrimination or by unlawful retaliation, the employer can terminate that employee at any time for good reason, bad reason, or no reason at all. Now, I do want to point out that we have talked today about employment at will. There are some employees out there, however, who are not employees at will. Generally, there are three categories of employees who are not employees at will. The first category is governmental employees. Certain types of employees of the federal government, certain types of employees of state governments, and certain types of employees perhaps of local, county, town, or city government are not employees at will. Those employees can only be fired for some reason, perhaps for just cause. I do want to point out, however, that the vast majority of employees of county and local governments are in fact employees at will who can be terminated at any time for any reason. Now, the second category of employees who are generally not employees at will are employees who are covered by a collective bargaining agreement. A collective bargaining agreement between lay people will be thought of as a union contract. So if you are in a unionized environment, you're covered by a collective bargaining agreement, then that collective bargaining agreement is going to state the terms under which a discipline up to and including termination may happen. So you'll know in there the reasons for which you may be terminated and how you can challenge that termination. The third category of employee who is not an employee at will is an employee who has an individual contract with the employer. In that circumstance, the individual employee, the worker, has a specific contract between him or herself and the employer that lays out the specific reasons for which the employee may be terminated and what are the ramifications of terminating the employee, say, with cause or without cause. I represent a lot of doctors, and many doctors have individual employment contracts with the hospital or the practice they work with, and those individual contracts specifically lay out the circumstances under which the doctor can be terminated. There are other folks who are covered, for example, high-level executives, certainly athletes, celebrities, entertainers, people who have very unique skills oftentimes will have a specific employment contract. But what I want to leave you with today is remember the vast majority of employees in North Carolina and in fact in the United States are employees at will. If you're an employee at will, you can be terminated at any time for any reason. Good reason, bad reason, or no reason at all. Thank you for listening to our lecture today regarding employment at will. Again, my name is Kirk Angel. You can find more information about me on the web by doing a web search of Kirk J. Angel or on my website at theangellawfirm.com. Thank you all.